Free speech is arguably the cornerstone of democracy, and it's arguably under attack in the United Kingdom for a number of reasons, some of which may be justified. For example, the Watch What You Say advisory note from the Attorney General regarding the trial for murder and attempted murder of Axel Ridderkabana in the Southport incident, or whether it's the more controversial, what does Islamophobia mean? We'll talk about all of those and a few things in this video, because some of those may be justified and some of those may not be justified. And so we'll look at a few of the ins and outs here. But first of all, if you're new to me, I'm Daniel Shensmith. I'm a barrister. I enjoy helping you to understand law, how it applies to everyday current life and events. So I'd really appreciate it if you subscribe to the channel. I know I ask, but it's the difference between 100 or 1,000 or odd people subscribing each time I ask. So forgive the persistence, but that's how to YouTube. So thank you for doing that. I really appreciate it. So where do we start with this? There's a number of different things to look at in this video. Now, this is very much a free speech topic. So for that reason, this article is borrowed from Free Speech Union. I am a gold member. Please do support them. Go if you value your free speech and you're ever worried about what you're going to say. This segment is not sponsored by Free Speech Union at all. They've not asked me to do this or say anything, but please do go support them. If you value your free speech, go and join. It's a small fee for a peace of mind. Now, they talk in this article about Islamophobia. Now, I make absolutely clear at the beginning, I do not condone racism. I do not condone targeting individuals and groups of individuals for these reasons, or any kind of hate and horrid speech whatsoever. I don't condone or support any of that whatsoever. In fact, I have many friends of all different faith, different sexual orientation. For example, my wife's Chinese. I train with people from all over the world, including of the Muslim faith, very dear friends to me, and so on. So all of that absolutely clear, but I do have to look at and criticize what is possibly being adopted as a definition of Islamophobia. Now, in one specific sense, I can understand the motivation for defining this and where it might apply. For example, let's take some of my friends who are of the Muslim faith. If someone were to target them just because they look Muslim or whatever, that's obviously not a very nice thing to do. I would object to that. I would defend them, and I would absolutely tear down somebody for doing that. Now, if they were doing that specifically because they appear to be Muslim, then this is really what this definition, this so-called definition of Islamophobia, is supposed to target. Now, in that specific sense, I agree. But here's the problem. It has a chilling effect on free speech, as described in this article. I'm not going to read it in full, but I'll link it below. You can go and read it. But the problem with it here is the definition as drafted by the All-Parliamentary Group on British Muslims. It says here, risks conflating legitimate criticism of Islam with prejudice against Muslims, creating a chilling effect on public debate. Now, for example, if you were to criticize someone for being an extremist of that faith, I would think many people who are genuinely of that faith would also criticize the extremists of any faith, of any background whatsoever. I think most people would criticize the extremists. I'm going to change the ISO on my camera. It's getting a bit dark in here. So if you were to genuinely criticize someone for being an extremist, I don't think that should be itself limited because it's a genuine criticism. However, the definition is as follows. It says a type of racism that targets expressions of Muslimness or perceived Muslimness. Now, the problem with that is an extremist doing something extreme would be an expression of Muslimness. And so if you were criticizing that, then by definition, literally by definition, you would be Islamophobic. Now, I don't agree with that. Now, in my original case, if there were friends of mine being targeted just because of that, then that's different. I mean, that still fits within the same definition, but that one's acceptable. But to have a blanket brush, a blanket definition is obviously wrong because it does squash free and legitimate speech and criticism. So I'll link this article below, and so far it appears that this is being used and adopted by Labour for internal purposes as well as the Lib Dems, the SNP, the Green Party, and several local authorities. And this is a problem because this means that this definition, such as it is being used in an increasing sense in various departments, and being doubtless will be used to target people who are forming genuine criticism. Now, I would only hope, but here's where hope may fall down, I would only hope that those who would be in a position to bring charges or whatever against individuals for making commentary would be able to see the clear line between the two examples that I've given. On the one hand, there's the extreme version, or as has been in the news recently with the rape gangs of a particular origin, etc. It's unfounded criticism to say that they are of a particular background. Whereas if they were friends of mine and someone's criticizing them just because of the way they look, yes, that's wrong. And I would condemn them for doing so. I would tell them off quite robustly, and they probably wouldn't do it again, certainly not in front of me. So I hope you see the difference, but I would hope, and here's where the eternal hope comes in, I would hope that those in power would be able to see the difference. But as we have seen, as has been demonstrated by the media and the stories and decades of what people call a cover-up, for fear, it has been acknowledged in some sense that there was a willful blindness to what was going on for fear of being seen as being racist by looking into and exploring certain reports. So that's all I'm going to say on that. I'll say go and read the article. I think that this definition has a problem. I can understand the origins of the definition, but I think that there is a line, and this definition just covers both sides of that line quite clearly, and I think that is an inherent problem. But then we look to perhaps what is more legitimate, more justified curtailment of free speech, and that is regarding this trial of Axel Rudakabana of the Southport incident. More on that in just a moment. Don't go away. Now, on another note, don't you just love it when a company does exactly what they set out to do? No stress, no fuss, reasonably priced, and it works exactly as it should. That was exactly my experience with Saley, and why I was very happy to have them sponsor this video. Saley is an eSIM service, meaning you get seamless access to the internet in whatever country of destination you're flying to, and it gave me absolute peace of mind when my son recently went abroad, because the first time he went abroad, my own mobile phone provider promised that it would be fine, but obviously it wasn't, and they insisted on sending a message to his phone when he was in that country when obviously he couldn't receive it. You see the problem that we had there. So the next time we used Saley, and it was absolutely seamless. You download the app, you buy a plan for the country of destination, you activate it before you leave, and then when you arrive, you get seamless access to the internet. And because Saley is brought to you by NordVPN, it comes along with enhanced security features as standard. So you can stay connected whilst having web protection, ad blockers, and a virtual location even as you are traveling around. For those of you wondering what an eSIM is and how it works, well, gone are the days that you have to wait for that little bit of plastic to arrive through the post and swap it out when you arrive in your next country of destination on holiday somewhere. This is an eSIM working seamlessly on your phone through the app. You download the app and pick a data plan for your country of destination. It will prompt you to install the eSIM, and your plan will activate automatically when you arrive. This means you benefit from no high roaming fees. You can have multiple profiles. The eSIM can't be lost or stolen. Obviously there's less waste, less bit of plastic flowing around, and you only pay for exactly what you need. Of course, as a partner to my channel, you get a great discount, which is 15% off using the code BlackBeltBarrister off any data plan you wish to buy. But of course, you don't have to buy it straight away. You can download the app today, so it'll be ready for when you go on holiday, and then you can buy a plan and it'll activate as soon as you go on holiday. So don't forget the code, it's BlackBeltBarrister with 15% off, and download the app today so you're ready. And thank you once again to Saley for sponsoring this video. So back to this media advisory note on the trial of Axel Rudakabana and the Southport incident. Now, in short, the advice is limit what you say so that you don't risk having the trial thrown out. That's it in a nutshell. The reason these laws are in place to restrict what you say is to eliminate, or ideally eliminate, the risk of this trial being thrown out. Because if lots and lots of people make lots of commentary, which ultimately the jury end up seeing, and if the jury is swayed, or the defense team argue that the jury is swayed by anything they see, read and hear on social media, so as to not have a fair trial, the trial may be thrown out. And that is obviously a serious problem. It's a serious problem for the natural course of justice in this country. So, with that in mind, I will not be speaking specifically about this case for obvious reasons I've just said, but I will be talking about this advisory note and why you should take heed of this advisory note. So it's a reminder, a relatively rare reminder from the Attorney General. It's routine to see it on the CPS website to say, just a warning, this is an ongoing case, please don't comment on it and so on. That's routine. But from the Attorney General to make a news publication here is obviously newsworthy. So it says, and as you'll know, Axel Rudakabana has been charged with 16 offences, including the murder of 3 young girls, the attempted murder of 10 other people, including 8 children, as well as the production of ricin and possession of Al-Qaeda training manual. The trial commences on the 20th of January 2025 at Liverpool Crown Court and is expected to last from 4 to 6 weeks. Now, obviously, many people will ask questions about the duration, why will it take so long, etc. But again, even posing those questions and having those robust discussions risks the trial being deemed to be unfair and thrown out. So I would urge you, I would reiterate this here for reasons I'll go into in just a moment in more depth, but I would reiterate this warning not to have those in-depth discussions. However much you would like to air your views and frustration, I would say please don't do that, so that you don't risk the trial being thrown out. The criminal trial commences. Whilst proceedings are active, the Attorney General is reminding editors, publishers, social media users that fair and accurate reporting of legal proceedings held in public in good faith is permitted. Now, this comes from the Contempt of Court Act. Live and accurate legal reportings, fair and accurate legal reportings. And so that means if you wanted to write about what has happened in court, what has been said in court, what the court, so you'll see the phrases, the court has heard. So this and this happened, the court has heard. It just means that's what's been presented in court. It doesn't necessarily mean that is a finding of fact yet. It is the jury that finds fact in a case like this at the end of the trial. Or as the case may not be, as you might find out in a minute. In another story I'll tell you in just a minute. So that's how you'll read this reporting of cases. The court has heard this, and it's an ongoing, fair and accurate. And if you report one side, you should also report the other side. So if you own your own independent news blog or whatever, and you report the prosecution's case in your blog, but then let's say you don't report the defense case, you've only reported half of the case. So then, if anyone were to see your blog and they only see half of it, I mean, the jury will be directed not to research the case and so on, but that's not the point. But if you only report half of it, that is not fair and accurate because you've only reported the prosecution side. You've not reported the defense side. And you should. If you're doing one, you should do the other. It needs to be fair. That's essentially what that means. And so if someone's tried for an offence and ultimately found not guilty, and you reported all of it except for the last bit where they were found not guilty, and you don't report that, then that's not fair. It's not fair reporting. So you really ought to do that as well. So fair and accurate reporting is permitted. However, you're at risk of being in contempt of court if you publish material or comment online that is inaccurate, unfair, or involves discussion or commentary which could influence jury's deliberations. This includes anything that asserts or assumes expressly or implicitly the guilt of Axel Rudakabana. This is due to the risk of potentially jeopardizing the criminal trial. The Contempt of Court Act 1981 seeks to prevent interference with the administration of justice and the right to a fair trial. That is the wording from the remainder of this advisory note here. So that is the warning to you about what you write and post online. Now, where does this come from? And how does it apply in other cases that may actually frustrate you? So again, not speaking specifically about that case anymore or at all, but where does this come from? Well, watch the comment section go crazy because we're going to talk about Magna Carta very briefly. 1215, Magna Carta was a very fundamental piece of law that underpins the rights and the freedoms of everybody in the UK today. Most of this is no longer in force, but Clause 39 is one such that is, and states that no free man could be imprisoned except by the lawful judgment of his peers, social equals, or by the law of the land. And so, in essence, this means trial by jury. And this was later confirmed in the Habeas Corpus Act 1679. And so, essentially, that means a trial by jury. You are entitled to a trial by jury, unless, of course, it's a summary-only offence. You are entitled to a trial by jury. Now, how does this come into play today, and how is that rather frustrating in some sense? Well, I shall borrow another article here from Magistrate's blog. I'll link below. Please do go and check it out. Show your support. Buy them a coffee with the link on the side there. Again, I've not been asked to do this, but please do support and go and buy a coffee with that link on the side for bringing these accurate news reports here. But this one, the hung jury in the Just Stop Oil Heathrow criminal damage trial. You'll have seen these individuals spraying orange paint everywhere on video. In many of these cases, there's no dispute as to what happened. You can see what happened here. You can see them. They are filmed walking down and spraying orange paint everywhere. It's uncontested that this footage exists and what they were filmed doing, etc. And in this case, Phoebe and Jane were accused of causing £8,000 worth of damage at Heathrow Airport on Tuesday, 30th of July. The valuation considerably less than the £50,000 estimate. They were on trial in the Crown Court, but yesterday the judge discharged the jury because it was a hung jury. A retrial will take place in 2026. So definitively kicked down the road somewhat. No, so the same applies here. But we come back to 1215 Magna Carta and the right to a trial by jury, or as it's interpreted today, a right to trial by jury. So in essence, what we have is this. On the one hand, we have the right to freedom of expression, say what you like, say what you think. On the other hand, that can be curtailed because it's a qualified right, and in one such way that it can be curtailed is if you are held to be in contempt by prejudicing ongoing proceedings and thus scupper the ordinary course of justice, that being in the Contempt of Court Act, and hence the media advisory note regarding the Axel case. So on the one hand, we have free speech. On the other, we have the principle where, well, everyone has the right to a fair trial, and so you can't just say what you like about these things, even if there is a video of them doing what they're accused of doing and they're on trial for causing the damage. Now, there's another article by Magistrate's blog. Again, I will link below. Again, please show your support. Ideological defences and trial by jury. Time for a rethink. Now, in this one, they were charged with and denied allegations of criminal damage and interference with key national infrastructure in relation to the incident where they sprayed paint onto an aircraft at Stansted Airport. They were also charged and denied allegations of aggravated trespass when they appeared in custody in June 2024. And as rightly penned in the article here, as they've denied the offences, one is limited in what one can say. However, there's no dispute that the allegations arise from their visit to the airport. It was filmed and uploaded to their social media channels. There was no dispute that they cut a hole in the perimeter fence, approached several aircraft, and discharged fire extinguishers containing orange paint. And so, predictably, lots of people asking the very valid question, how on earth can they plead not guilty to doing what they are ostensibly filmed doing? And so this ultimately then turns on whether or not there's lawful excuse, which is potentially a defence to criminal damage, or reasonable excuse for their actions, which is generally an excuse or defence against interference with key national infrastructure. Now, there was, as referred in this article, a Court of Appeal case that held that political and philosophical beliefs and reasoning and motivation of a defendant offering a climate change defence were too remote to constitute lawful excuse for any damage caused. But of course, in any such case, when defendants put forward divisive or political opinions, these can split opinion quite divisively, and of course that is demonstrated by this recent case for Heathrow Airport with a hung jury, which has now been kicked back to 2026. So this is very much freedom and free speech versus fair trial and the rule of law. So where do you stand? So I would on the one hand say leave your comments and let me know what you think below, but subject to the caveat that you obviously have to think about not jeopardizing any of these trials. But do let me know in general terms what you think about cases like this on a philosophical point and on such definitions as they might apply in society. But with that, please do like the video, remember to subscribe to the channel, and as always, thank you for watching.